because these are proceedings before an independent body, the Senate, and I'll refer to the matter case that I argued at the Supreme Court on the need to respect proceedings before other bodies, my Lord, and to shield those decisions from question. My Lord, I will let my learned friend deal with the last question, but let me deal with the question that was raised again by learned friends, or that Senate voted on a ground, or ground 8, which was founded on a repealed section of the Penal Code. My Lord, yes, my Lord, if I may go to this, my Lord, the caveat, of course, on this ground, my Lord, is that one, this court cannot undertake a merit review of the proceedings before Senate. And that is why I alluded to Article 145(7) on a motion passed, however voted upon by Senate. But nevertheless, my Lord, since my learned friend from this side, again Macharia, dealt with this question, I must respond, my Lord. My Lord, this ground 8, that they allege was based on a repealed section of the Penal Code, my Lord, was not substantiated. Senate voted against it. And again, I state, my Lord, that the establishment of one ground was and is sufficient to send the petitioner home. Of the 11 charges, my Lord, presented to the fourth respondent by the second respondent, only 5 charges were substantiated. 6 were dismissed by Senate in its own wisdom. My Lord, why we submit that you cannot undertake a merit review, my Lord, is because this court cannot sit as Senate. And if this court begins a merit review on every ground, the 11 grounds, and finds, for instance, that a ground unsubstantiated was substantiated, then this court will essentially be taking over the role of Senate. And since an impeachment is a quasi-judicial exercise couched in real politique, my Lord, this court would then be judicializing politics. You then convert those other questions, my Lord, to a judicial examination, and that would fly in the face of independence of the 3 arms of government as contemplated by the Constitution. My Lord, ground 1 was, for instance, carried by 54 votes. Ground 2, negative by 39 votes. It was defeated. The allegation in ground 2, my Lord, was that Deputy President Rigathi Gachagua had undermined the President and the Cabinet, and this was defeated. My Lord, ground 3, which was founded on Article 10(2), and which was that the Deputy President Rigathi Gachagua had undermined devolution, was defeated. The wisdom of Senate, always. My Lord, again, just to demonstrate to the court, ground number 7 again was defeated, and the charges were that the Deputy President, Rigathi Gachagua, was engaged in the crime of money laundering That was defeated by 53 votes to 13. And lastly, my Lord, ground number 8, which was, my Lord, that the Deputy President Rigathi Gachagua had committed crimes by continuously misleading members of the public through false, malicious, divisive, and inciting remarks, again was defeated by 40 votes to 27. My Lord, lastly, ground number 10, again, which was on gross misconduct by Rigathi Gachagua by openly or publicly insubordinating the president as head of state and government. Again, this was defeated. My Lord, all the other 5 grounds were votes were passed in favor of the impeachment, but Senate rejected 6 grounds. In fact, the petitioner should be thanking Senate for doing a good job and for rejecting 6 charges. My Lord, lastly, my Lord, is on public participation. I will just touch a bit on public participation and allow my learned friend to proceed from thence. My Lord, a textual reading of the Constitution and a purposive interpretation of the Constitution, or what Macharia would refer to as a holistic interpretation, shows that Parliament, and the term used is Parliament, apart from where or except where, excepting where the Constitution then says Senate sits after the National Assembly. Parliament is referred to as the body that is intended to undertake public participation. And therefore, my Lord, in considering the textual provision of the Constitution, the court must then go further and look at the standing orders of both Senate and the National Assembly. We submit, my Lord, that the standing orders of Senate do not contemplate public participation for purposes of informing its decisions on the impeachment charges. Once the court sits, or once the Senate sits as a quasi-judicial body, it considers matters before it with a judicial eye, not a political eye, my Lord. And consequently, the allegation that the effect that the fourth respondent who Senate ought to have conducted public participation is not only misguided, my lords, but is lacking on a legal basis. Senate considered the motion of impeachment from the National Assembly within the timeframes donated by the Constitution and Article 145(3) of the Constitution, and sat exclusively as a quasi-judicial body for purposes of determining all the charges against the then Deputy President Rigathi Gachagua. It was under no obligation to conduct public participation as it is not provided for in the standing order. But my Lord, again, it would have been ridiculous to expect Senate to undertake public participation on the charges. That would, my Lord, amount to Senate not only surrendering or ceding its power of trial, but engaging in acts that would not only be in violation of the Constitution, but of the standing orders of Senate, my Lord. The second respondent undertook rigorous public participation conducted between the 2nd to the 5th of October 2025. My Lord, on this question, the Supreme Court has pronounced itself on the practicality of subjecting every single act of Parliament to a fresh round of public participation. And this was in Cabinet Secretary of National Treasury versus Okia Okoiti Omtata and 52 others. The court pointing, my Lord, that while there's an obligation of Parliament to consider and give effect to the proposals, views, suggestions, and input from the process on public participation, it would be circuitous and not amount to prudent use of public resources to expect the National Assembly, in this case, Senate, to subject proposals, views, suggestions, and input from public participation exercise to a fresh round of public participation. My Lord, with the knowledge that impeachment was occurring, my Lord, the National Assembly having subjected the process to public participation, what use, my Lord, would the exercise have served had Senate involved itself in a second round of public participation? But secondly, my Lord, in terms of timelines donated by Standing Order 12 of the Standing Orders of Senate, my Lords, any attempt to undertake public participation would have not only lengthened the period donated by the standing orders for impeachment and or the submission of any reports before Senate. That would make impeachments, my Lord, open-ended and unable to serve the very purpose for which the Constitution provides impeachments, my Lord. My Lord, lastly, we wish to submit on thresholds, and this goes to the question of the restraint that we have addressed the court on. My Lord, my lion friend Ndegwa Njiro and my lion friend Mr. Ochel submitted on the question of threshold. And the Martin Nyaga Wambora case and the Speaker of Senate was cited. I think I litigated this one with Mr. Ndegwa Njiro and others, and Paul Mwite at some point in the Court of Appeal. The Wambora matters, my Lord, were several. But, my Lord, to wit that, and I fall back to 145.7. It is not open, my Lord, for the court to consider threshold once the National Assembly, by a vote of 1/3, admitted the charges or the grounds of impeachment before it, and once Senate, by a vote of 2/3, voted on the substance of every charge. At this point, my Lord, the court cannot find that the threshold for impeachment was not met. That would not only, my Lord, amount to violating, you'd be relating back, my Lord. The court would then be acting, 1 sitting as Senate, and 2 sitting as National Assembly, and 3 sitting as elected senators, my Lord. My Lord, I urge you to resist the urge to be elected members of Senate. My Lord, I urge you, let me rephrase, my Lord. I urge you to resist the urge, my Lord, to sit as Senate. Thank you, my Lord. My Lord, I urge you to reject the argument by my lion friend Mr. Ochiel and Mr. Macharia that there was a threshold question, because that is for Senate and the National Assembly to consider, my Lord. My Lord, several decisions have been cited in support of this ground. We have cited the Sonko decision on impeachment. We have, the Wambora decision is on the standards. I think in the Wambora decision, the threshold question for removal at the point was on whether certain acts constituted a gross violation of the Constitution. And the court then found that the Assembly needed to establish grounds not on a balance of probability, but above the test, in fact, beyond reasonable, to show that some of those acts or actus by the petitioner, then Governor of Embu, my Lord, were acts that were impeachable. My Lord, the Court of Appeal was setting standards for impeachment so that we do not have willy-nilly impeachments without a basis, my Lord. My Lord, unlike, and this is distinguished in the Wambora case, my Lord, the Wambora case must be distinguished from the Gachagua case. The Gachagua case had 11 charges. 5 succeeded, but 6 failed. My Lord, for an impeachment to be successful, only one charge must succeed. Only one, my Lord. The submission on threshold, my Lord, was therefore improperly made before you because it did not address every charge. In fact, it avoided addressing the successful charges. Instead, Daniel Friend Degwa focused on the charges against which Senate voted. My Lord, if I may cite the case of Kidero and Waititu and 4 others, this was a decision of the Court of Appeal that invalidated a decision of the Supreme Court that set aside a decision of the Court of Appeal that had invalidated the election of Evans Kidero and Mweke as the governor and deputy governor of Nairobi County. And while considering this question, the Supreme Court dealt with the question of fair hearing. I think this is one of the cases that set out the question of fair hearing. I think this point was urged by Senior Counsel Paul Mwite, if I remember, with vigor, and the court dealt with the question of opportunity. The court held, was there an opportunity for hearing to be given? And then 2, the reasonableness of that opportunity. But the court then went on to say that the court then must consider every case on its own merits, as the concept of fair hearing is an elastic one. Just to mention, my Lord, the case of Onyango Law versus the County Assembly of Kisumu, which is an appeal that I argued and won, and that has been, heavy weather has been placed by learned friend, again, that's not you, learned friend Paul Mwite, on the Onyango Law case. My Lord, Onyango Law had not been served with any charges. This is just to distinguish the Onyango Law case. He was never served with any formal charges. My Lord, the motion for impeaching Onyango Law was presented in the County Assembly of Kisumu at 1 p.m. They then looked for him on phone and asked him to appear in the assembly at 3 p.m. He was not in any hospital. But my Lord, when he attempted to come to the assembly, he could not access the assembly. He was blocked by youth from accessing the assembly, not goons. So he was never heard at all. He had no opportunity, my Lord, to file any documents before the assembly. He had no opportunity to appear by counsel. He was not present during the execution or the prosecution, my Lord, of the case against him as Speaker. And that is why the Court of Appeal set aside the impeachment, my Lord. Again, I successfully argued the appeal for Nyangolo. My Lord, given the time, I've exhausted my submissions before the court. As I had promised the court, my Lord, I'm fairly short, my Lord. Yes, my Lord, I'm fairly short. I'm very particular about time, my Lord, and I thank you, my Lord.
Before you sit down, we have had substantive submissions on the issue of public participation. We heard what Professor Guy said about public participation simply being an information process. We heard what the petitioner said about public participation, and all parties, when they conclude, they say that it will be determined on case-by-case basis. Now, what is the case-by-case basis on public participation on this matter? Where do you place it?
My Lord.
Because put it in the context that both petitioners and respondents, when they make their opening statements, they start by saying that this is a peculiar case, had never taken place in Kenya, involved the impeachment of the deputy president, and therefore impressing upon the court to be very careful about. So tell me the case-by-case basis of public participation in this matter.
Yes, my Lord, my lion friend, Mr. Macharia, submitted that 200,000 Kenyans took part in giving views to questions raised by the National Assembly, and that the questionnaire that was submitted was lopsided, as it simply asked the public to tick against questions. My Lord, our submission is that, again, the public participation, my Lord, should be viewed by the court against several decisions that have been made by this court, my Lord. I know several have been cited, my Lord, but against, my Lord, that an opportunity was afforded to Kenyans for 2 days to give views on the process. My Lord, the Constitution is slow. It does not say, of course, whilst public participation is a process and is donated by the Constitution, it does not say what the outcome or what threshold, my Lord, or whether once an opportunity is afforded to Kenyans to participate, that they must be compelled to all participate in that process. Because the question, and what the National Assembly Council has submitted on, was there an opportunity? Did the National Assembly provide through its portal, physically and otherwise, an opportunity for members of this country?
Maziwa yakipungua